we're going to go ahead and get started. So I'm thrilled to welcome you all to LLC Operating Agreement Essentials for Artists and Creators. And I would like to extend a warm welcome to each participant joining us here today. This virtual seminar, which is part of our ongoing series of online panels and webinars, is dedicated to equipping artists and creators with essential legal and business knowledge. My name is Weissman Law, and I'm an associate at Weissman Law. And it will be my pleasure to guide you through this very important discussion today. Artists and creators often chart their own paths, which makes having the right legal foundations, such as an LLC operating agreement, truly invaluable. I just want to note that while today's presentation will be focused on operating agreements for limited liability companies, operating agreements are also applicable and essential for any type of business entity that you might enter into. So from protecting intellectual property to delineating business relationships, these agreements truly serve as the bedrock for sustainable creative enterprises. We're here to delve into why an LLC operating agreement isn't just a formality, but it's a cornerstone of your success in the business of art. And while as bright as the future can be with the right operating agreement, it's equally important that we know the potential pitfalls in the absence of one. Without a proper agreement, artists and creators can face a huge field of complications. There can be disputes among partners over profit sharing, responsibilities, and the direction of where the business is going. A lack of clear terms can also lead to protracted legal disputes, which puts at risk not just your personal relationships, but your shared creativity and all of your hard work. Today's seminar is also going to shed some light on these challenges, and it's going to emphasize the importance of taking certain preemptive steps to avoid these hurdles and to help you focus on what you truly do best, which is creating and innovating. So I have the pleasure of introducing our distinguished speakers for today's seminar. First, we have Adam Weissman, the founder of Weissman Law. Adam brings his rich background in supporting creatives from various sectors, and he's going to be sharing his knowledge on why tailoring every facet of an operating agreement he's going to be sharing his knowledge on tailoring every facet of operating agreements to the unique pace and rhythm of creative businesses. Also joining us today is Emily Poehler, the founder of Poehler Legal LLC. Emily's remarkable expertise in dispute resolution and commercial litigation, especially within the creative fields, will illuminate the proactive strategies that artists can implement to safeguard their work and their collaborations. After our discussion today, we'll open the floor for a 20-minute Q&A session where everyone here will have the chance to ask questions and to engage with our speakers directly. And as always, please, your participation and questions are highly encouraged. Before we dive in, I do need to disclaim that the information presented in this webinar here today is for informational purposes only and should not be considered legal advice. So please consult with a qualified legal professional for any sort of guidance on a specific legal matter. Now, let's begin our journey into LLC operating agreements and discover how they can be crafted to support your artistic and business endeavors. Adam, the floor is yours.
Thank you so much, Lorena. So let me get started just by sort of repeating something that Lorena said, which is everything we're going to talk about today certainly applies to operating agreements, which are the foundational agreement that you would be creating for an LLC. But many of the concepts that we're going to be discussed, whether it's on my side with the transactional pieces or on Emily's side with the litigation pieces, also applies to other forms of business partnerships, whether it is a corporation and what you might want to insert in some of your bylaws or other guidelines, or even something less formal like a non-corporate, non-company entity partnership between individuals. Now, the reason we want to have this conversation, we're at the start of the year, new beginnings. People are creating new companies now. And one of my number one gripes as a transactional lawyer is getting a client who's been operating for years without having a proper operating agreement in place between the members or the owners of that company. It is so crucial to take these steps at the infancy of your company to decide how your company is going to run, to then deal with potential pitfalls that may come along as you start developing the company, as it grows, and really, frankly, as you start getting more successful and there's more money on the table. So what we're going to be talking about with my part of the section are some of the major considerations that I help guide clients through when we are developing operating agreements between multiple partners. Now, note that if you are creating a single member LLC, especially in New York City, where we're all practicing, you should be putting together an operating agreement for yourself also. That being said, a lot of the considerations that we're going to go into today are not necessarily going to be important. If you're a single member, you're running the company completely by yourself, you don't necessarily need to think about all of the different issues we're going to go over today, which really at the heart of it just get down to what happens when there are issues between partners. So that being said, if you have questions about single member LLCs, feel free to reach out to us after, and we're happy to chat about those. Now, I'm going to talk about a number of things. Hopefully, both Lorraine and Emily will interject as I'm going through things, but these are sort of some of the major issues we think about. And we are specifically talking about companies that have some creative aspects to them, whether you are creating a single purpose vehicle for a film and you're have a bunch of production partners, whether you're a new creative agency and you're bringing in a bunch of people to run different aspects of the company, or even if you're running just a social media channel with a couple of people. These are all the things you want to consider as you're getting started to protect yourself up front. And then in the worst case scenario, if and when the relationship starts to fall apart and somebody wants to get out. Now,
and Adam, can I just,
yes,
before you go, I'm taking you at your word about interjecting. So
please.
Before you go on, I think it might be helpful to sort of define, because a lot of this presentation is focused on intellectual property, it might be really helpful to talk a little bit about what we mean and
Yes.
don't mean by that. So I think primarily we're going to be talking about copyrights, which are generally speaking audiovisual written works, plays, photography. It could be architectural plans, things of that nature. We're going to talk a little bit about trademarks, probably a little less so, and those are things that sort of identify a business by its name or its logo, things like that. And then I don't know that about you, Adam, but I'm going to touch just for a hot second on the right of publicity, which is sort of a lesser known intellectual property right, but it's sort of gotten some attention recently in a fight between two social media influencers. And so I think it bears some mention, and that's basically the right of an individual to control the use of their name or likeness or voice. So I'll come back to that.
Yeah, no, thank you for raising that. And that's going to be really the through line with a lot of the items that we talk about today. A lot of people who are starting these companies are coming in with certain types of intellectual property, whether it's pre-existing copyright or bringing in trademarks. You have to talk about, which we'll get into, what happens to those things and what happens to new things that are developed while the partnership is going. And then, of course, you need to talk about what happens at the end, if and when this LLC decides to get dissolved or somebody wants to leave and bring things with them. But before we even get to that stuff, I want to talk about some fundamental pieces that have to do with just identifying ownership percentages and contributions that signify what ownership percentages are like. Every LLC is made up of 100% membership interests. And when you're starting with partners, you need to decide who owns how much percentage, who holds how much percentage. Now, if people are all contributing cash as their capital contributions, which is what we'll call them, the ideal is that if you have 50%, you're contributing roughly 50% of the capital contributions to that. And if you have one partner, they're contributing the other 50%. Now, the reason I want to talk about this at this stage is because particularly in the creative industries, it's really common to see certain people not necessarily putting in money, but putting in either pre-existing intellectual property or a thing called sweat equity, which would really just be a way of saying, I'm putting effort into this company. That effort is worth something. And as a result, I don't necessarily have to put in the dollar amount that the other partners are putting in. Now, that is all good and fine in theory. But what you need to absolutely do is acknowledge the value of that contribution, whether it is a piece of intellectual property or a whole catalog of that, whether it is the amount of work being put into the company from the outset, or that dollar value. And you actually have to create language explicitly acknowledging that sweat equity is going to be recognized as equivalent to the dollar value that it's set out as. If you don't do those things, what could end up happening if there's a dispute later on about the company between the partners, that initial value, if it wasn't recognized properly in the operating agreement, could be seen as null and void and discounted completely. So that's one of the very first things you need to think about. What am I putting into this company and how much is it worth? And how is that then reflected in that document that we have there? Now, one thing to note, this operating agreement is something that you're going to be creating at the outset of the company, but the capital and what people contribute over time might change. So if that changes, you need to identify that either in some form of amended operating agreement or a rider to the operating agreement where you're actually capturing those changes as you go. That's something that you're going to also want to decide how you implement it with your members. That might be actually written in your operating agreement every time someone adds capital, here's what we do, or we'll get more into this after. It might just be something that you decide with your members via decision-making powers. I see Lorena is trying to jump in.
Yeah, Adam, I was just going to ask, so would you say that that's kind of like a custom clause that if you're working with an attorney who's drafting your operating agreement, you would tell them, please, like these are the sweat equity that I'm adding to the company, and how is that going to be reflected in the operating agreement? Is it a specific clause, or what does it look like?
Yeah. So usually what we have in there is what we call a cap table or a contribution table. That is literally a table in the document that says, this is this member, this is where they live, this is what they contributed, and this is their ownership percentage. So that's going to exist in most properly drafted operating agreements in one shape or form. Now, when we are bringing in sweat equity, what you should be doing is adding in a clause somewhere around there before or after explicitly acknowledging that. And that's not going to be something that you find in, let's say, a template that you might just get from online by default. It's something you need to think about, because if someone hasn't taken the additional step to actually set it out there, it's not going to be acknowledged or recognized. So once you have that, you have the sort of foundational piece. We know who owns what percentage of the company. But simply because you have language saying that I own, let's say, 51%, it doesn't necessarily dictate how the company is going to be run. This is something you need to think about. One of the more complicated pieces that, let's say, Lorraine and I work on together when we're working with clients to create an operating agreement is deciding how decision-making authority is made. And it is incredibly important to get down to a T, particularly when you have companies that are made up of even numbers of members. It's pretty easy to use a just like majority rule for odd numbered member companies when you have 3 or 7 people, because there's always going to be somebody to tie break. But a lot of times, I would say more than 50% of the operating agreements we're putting together for multi-member companies are just 2 people. And the most difficult thing to think about when you're starting a company is what's going to happen when me and my business partner disagree on something. It's not really something you want to consider. I totally appreciate that. And it can be a bit of a tough conversation. But the reality is, if you have 2 people with 50% interest in the company who are deciding they have equal say, there is going to be a time when you get to a deadlock situation where you might not be able to figure things out. So what you need to do from the start is decide what your roles look like, and then talk to your lawyer, whoever's drafting this with you, talk about how that can be reflected in the agreement itself. And there are many, many ways to do this. I think what's great about LLC operating agreements is, yes, there are laws, there's the LLC code that we have to follow, but as far as what an LLC operating agreement looks like, it's really a choose your own adventure thing. So what we do in these situations is we'll talk to the client. We'll say, hey, do you have prescribed roles? Is one of you more on the business side, kind of signing deals with partners and brands and things like that, while the other person is more leading creative? And that, if that's the case, we go, great. Let's sort of explore that more and tease that out. Or do you both have very similar roles where you're doing a lot of the same things on both sides, and it's harder to tease that out? If that's the case, there are a bunch of ways you can deal with it. You can come up with deadlock provisions saying, hey, if we disagree, we'll go through this period. If we can't figure it out after 5 days, this is where we're going to go next. And maybe one person gets the veto power. Or sometimes we even have references to outside parties who get to decide issues when 2 partners on the same side of 2 partners who have equal say can't figure things out. Really, like I said, the world's your oyster. We can put anything in that agreement for the most part when it comes to decision-making powers. The other thing you want to consider is what warrants decision-making powers. Actually, I think I'll also be remiss to not mention that so far I've been mostly talking about operating agreements that are member managed, meaning the owners manage them themselves. Many operating agreements will also set out a totally specific or separate, or maybe just one of the members as what's called the manager, who gets actually the authority to make a lot of these decisions themselves. But again, it's up to you how you frame that. And what I was going to get to next was you get to decide in conjunction with your lawyer what decisions warrant sort of coming together as members versus maybe what's going to be a day-to-day business thing that doesn't need everybody's consent versus major decisions that need complete unanimous consent. So just to kind of put those things into perspective, you might not need your other members' consent to sign a $1,000 vendor contract. Maybe that's just part of doing business and you decide that's okay. So we'll say that in the operating agreement. But you might need your members' consent, or at least mutual, or at least 51% agreement between them, depending on how many you have, to sign a $10,000 contract. And then you might want to specify on top of that, you absolutely need unanimous consent to decide to buy a whole other company and incorporate it into LLC. These are just examples, and it sort of just demonstrates the level of commitment that you want to think about when and where you're going to want your members' input. Again, the reason you want to have these conversations right now is everything might be hunky-dory at the outset, but it's inevitable that if you're running a successful company, you're going to start butting heads about something somewhere eventually. And it's a lot easier to get to go back to your operating agreement, see what the decision-making process was supposed to look like, and let that drive it rather than having to fight, and worst case scenario, having to bring in an outside party to mediate or arbitrate or however we get there. There's usually ways you can get, or litigate. Yeah, worst case scenario. Although, Emily's probably not too upset about that coming up sometimes.
Yeah, it keeps me yeah, and I just want to say, I mean, I frequently, just to add on to what you're saying, Adam, I frequently I have clients who come to me who are like, oh, I didn't do this up front because, I didn't want to be seen as too aggressive, or it felt hostile or something like that. And I'm not sure if my screen is freezing just for me or it's okay. Well, I'm sorry.
It's frozen.
Hopefully you can all hear me. There we go.
You're unfrozen.
Okay. But the thing is, and I guess the other thing I hear a bit is like, oh, we didn't want to spend the time or money on this. Let me just tell you that litigation or disputes are time consuming and expensive, and you're not saving yourself any money in the long run, generally speaking. A and B, there's like a sort of saying, I guess, that I tell a lot of people, like, which is good fences make good neighbors. And you're not being argumentative or difficult or any of those things by setting this out in advance. You're just sort of it's better to think of it as just sort of laying the rules of the road, and so that everybody knows how things are going to operate.
Yes. And particularly in the industries we operate in, we represent a lot of artists and creators and people who have their focus more on the creative side. There's a big part of getting over the discomfort of bringing these things up as early as possible. Like Emily says, what you're doing when you're creating this agreement, it's setting expectations. It's giving you guidelines to say, if and when something goes wrong, we already had that tough conversation, so we don't have to deal with it in the moment when it will be much more emotional and tougher to figure it out. If you are already in, let's call it a minor disagreement with your partner, you're not going to want to discuss sort of the meta issue of what is our decision-making process. You're just going to want to get right into it. So having that conversation before you have any sort of issue is absolutely crucial. I'm going to cover kind of a couple more issues before I hand this over to Emily, but they're sort of interrelated. And that's thinking about going back to intellectual property, what you're bringing into the company, what the company's creating, and then what you might leave the company with if the company dissolves at some point. Now, Emily, correct me if I'm wrong, but I believe the default is if you're a member, your work that's being contributed to the company's, in theory, owned by the company. Is that correct?
Not exactly. And I'm going to talk about a case I had about a year ago where that exact issue came up. So can we pause on that subject?
We're gonna put a pin in that. But the reason I wanted to bring that up is because it is crucial to actually address this stuff in your operating agreement. Copyright is the default in copyright laws. If you created something yourself and there's no contract stating otherwise, you're the owner of it. Now, there's a whole bunch of employment exceptions and other things we can talk about, work for hire language and other contracts that are not the subject of today's talk. But the bottom line with matters of copyright, again, this is so crucial. If you're creating a film, you need chain of title, which means you need to own everything you're creating. If you're creating a creative agency and your clients need to own everything that you're creating, that the people contributing need to have sort of a work for hire style structure back to the company. So one thing you need to start thinking about as you're drafting this is what that the members create while they are acting as members or simply while they exist as members is going to be owned by the company. And that's going to copyright, it's going to trademark, it's going to patent, which we're not going to talk about today. But that needs to be drafted somewhere, whether that's in the operating agreement or potentially could even be in a separate contractor agreement that a member is signing. It's something that you need to address up front. The last thing you want, and I know Emily's going to go into this way more than I'm about to go into, but the last thing you want is somebody leaving the company claiming that they own something that they created while the company was in operation. And then you have a dispute over ownership. So you need to think about that in the middle of the company. The other things you need to consider, however, are if someone's coming in with pre-existing IP, again, whether it's some sort of film property or just some ideas or logos, are they giving that? Are they actually signing it to the company? Is it being licensed to the company? And then what happens if that person leaves? Do they get to take it with them, or is it going to stay with the company? These are things that need to be addressed in writing, because if they are not set out very explicitly, they can easily become the subject of litigation when the relationship falls apart. And that is really a major issue that I see as a transactional lawyer all the time, where I'm confronted with people who have been working together for a year and a half, and they ask me, hey, who owns this? And I look at the paperwork and I go, it's totally up in the air. Now we have to get Emily involved. So having that conversation is incredibly important. And then also talking about who gets to leave with it is a big deal, because what could end up happening is you get to this stalemate point where you've developed this wonderful company, whether it's a brand or, again, a creative agency or management company, and there's all this IP that both owners who are leaving want to take with them. And if that's not written in the contract, who owns what, it's either going to be a very difficult contextual exercise that the courts maybe are going to get involved with. But again, Emily's going to get into that, not me. Or you're just going to have a bidding war, which is just muddy and is not fun. And in our experience, can take years, even if you're not headed to court. So those are the things you want to think about. Now, the very last thing I'll leave you with is
Adam, I was going to say, like, kind of piggybacking off of that, not like any sort of pre-existing IP, but how about if someone, kind of has their own individual creative project, or like in the process of being a member of a company, like they decide to have their own side hustle, how could they make sure that they're able to do that and that it's not competing with the interests of the company or with their role as a member of the company?
Yeah, that's a great question. It was actually just exactly what I was going to get into for my last point, which is a lot of artists and creatives do have, either side or main hustles or other things going on that if those are not addressed properly in the operating agreement, we could go back to the issue I was just talking about, some lack of clarity about who owns those things. So let's say, for example, you are working with a partner to create a podcast production company, but on the side, you happen to be producing a couple films. You want to make sure that there's no non-compete in the operating agreement that restricts you from doing that, because there's a world where two kinds of productions could be seen as not competitive. So you might want to actually explicitly acknowledge it. And then B, also state that, hey, this is not going to be subject to any sort of work for hire or IP assignment language that's captured in anything I'm doing. Really, really common to have multiple things going on if you're working in the creative space. So make sure that's addressed. Make sure your partners understand that. The other pieces too, on the flip side of that, if you are in the business of, let's say, working with a lot of clients and you want to keep your clients, you might want to include some non-competes in there to make sure that your members are not going out and poaching the clients for their own side business, taking away from the main business. These are conversations you need to have up front. Otherwise, they're going to be much more difficult to have once that business is up and running. So that's sort of it for me in a nutshell. Those are the major issues that I talk about with artists and creatives when they're working on multi-member LLC agreements or operating agreements and other partnerships. Now, there are so many other things you need to think about in an operating agreement. You need to talk about what happens if a member wants to leave. How does buyout work? What happens if a member gets divorced and their partner or their former partner is entitled to a portion of that, you got to get into things as nuanced as that. You have to talk about how the LLC is supposed to be taxed, and that's something you're going to want to check in with your accountant about. An operating agreement has a ton of different things set out. All that being said, you will need to figure these pieces out. You can't take what we're telling you today and just sort of run with it and draft an operating agreement, because there are a lot more things to consider. But what we'll do is towards the end, after Emily's done her piece, we'll turn the chat open and allow anyone with questions about things maybe that we didn't cover to ask them. But with that, I'm going to turn to Emily to talk about the fun world of disputes and litigation.
Okay, thank you. So I guess I'm in some ways picking up where Adam left off, or my presentation is a little bit more about all of the bad things that happen when either there's no operating agreement, or you did, and again, I don't know why my screen is freezing, but here we are. So hopefully it'll pick back up in a minute. Anyway, where there's no operating agreement, or something was created through LegalZoom or something similar, which on the one hand, it's fine, but it's really not great. I'm dealing with one now, and it's just, there's a whole bunch of the considerations that Adam was just talking about that get left out of those kind of agreements. And the other thing,
LegalZoom is responsible for about 10% of our clients come to us. So yeah. It's fine for us, might not be fine for the clients. So
yeah, it's just not great. And the other thing I think I see a lot of is that people come to me where somebody wrote an operating agreement 10 years ago or 5 years ago and then stuck it in a drawer, and people have left the business or joined the business, and the business operates in a completely different way now than it did when the agreement was first written, and nobody's sort of put that down on paper anywhere or on a computer screen and signed it and reflected these updated procedures or processes or ownership in an actual document. And I think, as I said before, look, I understand that everybody's busy and there are a million demands on people's time, and it's can be costly to hire a lawyer, but litigation or disputes are not only taxing in terms of time and money, but emotionally, frequently, are really disturbing and really upsetting for a lot of people, because they've put their heart and soul into a business, and then they have to get in a fight with somebody they thought they could trust. So let me come back to, why do disputes happen when there's not an operating agreement, or the operating agreement was done by LegalZoom or sort of stuck in a drawer and nobody thought about it for 10 years? Well, a lot of that has to do with the fact that where there's not an operating agreement, or not an operating agreement that's usable, there are default rules that apply. So, for example, Adam was talking about capital contributions and sweat equity being a form of a capital contribution. Well, if you draft an agreement, if you don't have an agreement that reflects that contribution of sweat equity 5 or 10 years down the line, after you've been working in a business and contributing, your partner can say, sorry, you've contributed $0, and I'm going to take over this business. So that's an important reason. And the flip side of that is, you could have a situation in which one person picks up and walks off and is like, well, I was never really a member of this company because I didn't put any dollars in, and it's not really reflected that I contributed anything to the company. And then you have a situation where the company has either taken control of somebody else's work, or has had somebody who has been providing very important work to the company take off. Sorry. Another place where this could come up is, for example, you and a partner have a handshake deal that you're both going to contribute your full-time energy to the business. Well, one of the partners, and this is a situation I see quite a bit, one of the partners decides, you know what, I want to move to California. Business is based in New York. I'm just going to pick something that's, very much in person. It's a Pilates studio, but I'm going to move to California. Well, you now have a partner. You now have rent due on a space in New York, and you have a partner who's living in California who's not available to teach Pilates. Well, the default rule there is that that person still gets 50% of the profits of the business. And that's probably not an ideal situation. And unless you have something in your operating agreement that reflects that you're both going to be present and work in the business full time, that's a problem you can very much run into. There are also default rules over the ownership of intellectual property. And coming back to something that Adam raised, with copyright, the copyright, generally speaking, vests in the person who created the copyright. What does this mean? This means that without a document saying that the copyright goes into a business that you and your partner share, the copyright may rest in the person who created the work. So I'm just going to give you an example from a case I had about a year ago, which I mentioned a little bit ago. So in that case, I had two people. I represented one of them, and this is a publicly filed case. One of the two people had worked together for about 10 years on a documentary film. And they'd formed an entity, but they didn't really make sure people were both members of it, all sorts of problems. They also didn't document what was going to happen to any of the materials that they shot in connection with this documentary. The case settled, but one of the biggest things that I argued in this case on behalf of my client, who shot the majority of the footage, was the footage never went into the company because she was the sole person creating that footage, and therefore she controlled it. Not a great thing to find out, 5 or 10 or even a year into a venture with somebody else. That's not the kind of thing you want to learn down the road. So another thing that's important to mention, where two people create something together, again, there's a slightly different default rule. The general rule is that those people both own that work. And where this comes up is that both people can then use it without the other's permission. And that opens the door for somebody creating a competing venture. And the only thing that the person who creates this competing venture has to do is, pay half of the profits to their partner. So you have a potential for somebody to create, let's say, again, a competing documentary film based on footage the two of you jointly shot without your permission. And that sort of can very much muddy the marketplace, and you can end up in a world where are there two competing films that use the same footage?
It's also particularly important to hash out if you are running a company that is doing any sort of work for clients underneath you. If you are some sort of creative agency or marketing company in that space, your clients, depending on what you do, might expect that you're actually going to be transferring full ownership to them and have restrictions on the way you can use the work that you've created for them. If you have a rogue partner who believes that they have ownership or technically does have ownership over something that you created for a client, and they go off and use that, your client's going to be furious. And best case scenario, they'll just terminate your contract. But worst case, you could be sued for copyright infringement and a whole slew of other issues arising out of that. So absolutely something you need to consider.
And there can also be similar issues, and I certainly see it come up with respect to the ownership of trademarks. The issues around trademarks and disputes over who owns trademark are generally a little simpler, because usually the presumption is, and Adam, correct me if I'm wrong, that the company, generally speaking, owns the trademark. However, sometimes, to use Adam's word, a rogue partner or rogue employee goes out and registers a trademark in their own name, and that can create all sorts of problems. So again, this comes back to why it's important to have sort of the rules of the road set in advance, because it really limits the possibility for this kind of mischief. And I will say, generally speaking, again, with trademarks, the rule usually is that the company owns the trademark, but you then have the possibility of having a company where there's two or more members, and can they each go out and use the trademark independently of the other? It's a messy situation. It's where I frequently get involved, and frequently when I get involved, there's a lot of hard feelings, a lot of, years of anger or feeling ignored or disagreements or things that have sort of been put off for another day, which makes my job rewarding. It is one of the things I like about my job, but most people, I'm weird, and most people would not find that enjoyable.
I would not find that enjoyable. But Emily, correct me if I'm wrong. With copyright, we really just look at the instance it was created. But what makes trademark even more difficult is ownership is based heavily on actual use of that mark in commerce. So if you have 5 years of use with multiple parties involved and no clear distinction on paper who's supposed to who's supposed to have the interest in that trademark, you're going to have to look at 5 years of contextual history to really suss that out, barring anything in writing beforehand.
Yep, that's right. And so then I just really have one, again, I froze, sorry. One last thing I want to talk about that I sort of touched on a little bit during Adam's presentation, and that's this idea of the right of publicity. So the right of publicity is a little different from things that we've otherwise been focusing on, like copyright and trademark. Unlike copyright and trademark, the right of publicity is, generally speaking, a creature of state law, which means it's a little bit different in each state. And the right of publicity basically allows a person to control the use of their name, likeness, image, their voice. It can also extend to sort of even somebody representing somebody with a robot, for example. Anything calls a particular person to mind. So there's a pretty famous case in the world of the right of publicity where, and I don't remember who it was, somebody created a robot that imitated Vanna White from the real Wheel of Fortune, going back a ways. And that robot was found to have violated Vanna White's right of publicity, because even though nobody would look at that robot and go, yeah, that's Vanna White, it called her to mind. So this doctrine has pretty broad applications. And one of the reasons, and one of the ways it comes up in partnership disputes is, again, this idea of who can use what and when can they use it. So, in the situation where you have somebody, for example, who's a social media influencer who is promoting your business, is a member of the business, but is also promoting the business on TikTok or on Instagram or wherever, and that person decides, you know what, I'm out. I don't want to do this anymore. Can they then go hire themselves out to a competing business and work for that competing business, presenting that competing business's products on social media? And that's pretty much all I have to say. So I just wanted to leave a little time for questions, and I see we're at the 45-minute mark. So
this is perfect. Thanks, Emily. Yeah, yep. I think we'll turn it to the chat box. If anyone has any specific questions, please feel free to ask. Like we mentioned, this is just sort of the tip of the iceberg when it comes to things that you need to think about when working on operating agreements or when you have disputes with your other members. So any questions here, please feel free to type them in.
I think you can also maybe raise your hand, and if you want to request for me to allow the video or your audio, then please let me know if you prefer to ask your question out loud.
If not, Lorena, do you have questions?
There are no questions. I have so many questions. Yes.
Perfect.
So Adam, Emily, I have questions for you too, but I just want to give you a sec since you just spoke. So okay. Adam, could you please, talk about maybe a custom clause that you've included in an operating agreement that maybe you and I have drafted, or maybe before I joined, for a creative client, and explain how important that was or what it did for the the LLC or whatever enterprise in the long run.
Any custom clause?
Yes, maybe kind of like what we were talking about earlier about decision making. I know that you and I have worked on pretty specific kind of deadlock provisions or specific non-compete provisions. I think those could be good examples to maybe talk about.
Or you might want to talk if there's one that has to do specifically with intellectual property that comes to mind. That might also be sort of interesting to the group.
I do have one that I sort of alluded to a bunch of times, which is somebody coming in with an established property, in this case, a brand, and the business partners are completely happy to give the brand back to the person bringing it in if the partnership dissolves, of course, with some payment for the added value. So talking about that, brand exists. Individual A wants to partner up with a bunch of other people, take the brand to the next level, but goes, hey, if this doesn't work out, I want to make sure I'm the one walking away with the brand, not you other folks who came in to help build this up. What you need to do then is explicitly acknowledge all of that IP, the copyright and the trademark, and any other related bundle of rights, which might include some right of publicity as well if there's influencers involved, which the one that's top of mind did have that. And then say, we're putting this into the company. While the company develops, there's going to be more value added to this bundle of brand rights. We acknowledge that. If and when anyone decides to leave, I, as person A, get the option to walk away with this, and I will pay you XYZ. And usually you'll have to come up with a formula for determining the value. That's sometimes where we bring in accountants or evaluators to work on that. Numbers are not necessarily lawyers' strong suits unless you're talking to a tax attorney. But having that set out explicitly is crucial, because if you don't say who gets this IP when the partnership dissolves or when someone tries to walk away, it will be an argument. And those things, particularly if there's a lot of value built into that brand over time, could be an argument that takes years. And there might not be any clear answer to it if there's no disposition of it in the operating agreement. So working that out up front and figuring out the formula, even if it seems really rote at a stage when you're trying to build, is absolutely crucial.
Thank you so much. That was really helpful. Could either of you please talk about maybe the kind of like what kind of role do you see digital media or any sort of new technologies playing in terms of operating agreements for creatives in the near future? And if that question doesn't make sense, I don't know, what kind of techie evolutions? Yeah.
This, I think, goes back to a little bit about what I was saying about like one of the situations that I see happening a bit is, or where I get disputes frequently, like if there is an operating agreement, somebody's written it and stuck it in a drawer or on, some computer and not looked at it in, however long. So look, as we all know, technology is constantly evolving, and the case law on things like who owns a social media profile are constantly evolving. Things around scraping, data scraping from websites is evolving. There's all sorts of new and developing areas of the law, particularly how the law and technology come together is constantly evolving. And if you don't sort of take the initiative and at least set guidelines, in an operating agreement, however long ago, and then hopefully continue to update that as the business changes and as the business shifts, that's where I really see, some problems.
All right, we have a question from Leah, which says, specifically with film, how would you handle the inevitable dissolution of the film's LLC with future payouts? I've had it happen a few times in indie film where producers will dissolve the LLC and then years later the film actually makes some money, but there aren't clear guidelines if the film owes payouts to anyone because the producer thinks the entity that owes the money no longer exists. Therefore, the obligation does not exist. This is a good one, and I actually have questions like this all the time. I haven't had to deal with it personally. I will say, if you've created a single purpose vehicle for your film, a single LLC that's going to house the LLC, the reality is you should not be closing that. while the film is still, let's say, alive, for lack of a better term, if there's any sort of distribution on the table. Now, I have had situations where clients have closed their LLCs for their film, but what they did before the LLC was closed was they assigned the film in its entirety, plus all of the obligations attached to it, to them personally, or maybe to another LLC. And then those rights sort of just jump over. Now, that's the best case scenario. I don't know, Emily, have you ever dealt with this sort of situation?
Yeah, I mean, I think that there would theoretically be a claim of some sort for, I mean, there's sort of a lot of different hats that this, or a lot of different names that this could go by, but generally speaking, there's this idea of a constructive trust, and where sort of people create something together or jointly own something, like nobody is allowed to take all of the profits from that thing. So I think here you'd be like looking at some kind of argument that any profits generated, even though the entity was closed, are sort of jointly owned by everybody involved, and therefore should be distributed, accordingly. And the other argument would be something along the lines of what lawyers call unjust enrichment, which is basically whoever the person is who is getting the money is quote unquote unjustly enriched because they shouldn't in good conscience be allowed to keep all of that money. But again, going back to Adam's point, I think, the better path here is it's not super expensive to keep an LLC alive. Maybe there's a nominal tax filing fee. There's New York State, I think, is $9 every 2 years for, to keep the company alive. It's not, it's probably worth that not huge expense to just have that thing still floating out there, have the LLC still floating out there.
That's definitely how we would advise people in those situations. I know it looks like Leah's perspective is she was not the lead producer. She did not get to make that choice, and somebody closed the LLC without really running by her. Now, kind of question off of that I have. So let's say the LLC is closed. Let's say an action for unjust enrichment or some sort of trust-related claim is raised. If the operating agreement was drafted properly to talk about how proceeds are supposed to be handled, would that still be used potentially to guide a decision maker in allotting out payments?
Well, one thing I would want to look at the operating agreement for is whether the entity could be shut down without the permission of all of its members, because there might be, and I've seen this happen, some argument that somebody took it upon themselves to dissolve the business, and that really shouldn't have happened without everybody's say so. And then remind me sorry, I got lost on a tangent. What was the rest of your question?
If we do get to a point where, let's say, a judge decides, yes, these people should have been given some percentage of the proceeds, could the original layout in the profits distribution from the operating agreement control?
I mean, I think generally speaking, I would say yes. And I would also say that a court would look at probably the K-1s or other tax documents that sort of show how the ownership breakdown of the company. Generally speaking, courts are more inclined to look at written materials in deciding, this is how I think this should go. This should be broken down 25%, 25%, 25%, 25%, rather than being, they're generally less inclined to look at or to consider somebody coming into court and being like, oh, but we replaced that agreement with an agreement that it would be 50-50. And it was a verbal agreement. And, courts generally are not happy about that. And there's a whole bunch of laws saying, in fact, the courts should not do that.
That makes sense. Yeah, and I think I see someone's typing a question, so while that's coming in, I will say, especially in the film world, it is so crucial to get all this stuff up front. If you are making an independent film and you want to be able to distribute your film, if you cannot show that you truly own the thing that you're about to distribute, your film will not get picked up.
Yep.
And you will have problems
100%.
With future films as well. Because the last thing a distributor wants to deal with. Yeah. Sorry, go ahead.
That was 100%. I mean, that was, one of the issues in the case I talked about, because, the film couldn't be sold and nobody was going to buy it until the issue of title was cleared up.
Yes, Exactly. No distributor wants to be at risk for, again, some rogue partner suing them when it was completely out of their control. We have got a couple minutes left. I do see someone typing in the chat, but maybe I'll turn it back to Lorena for a minute while that's being typed up. Lorena, any other questions you have for either of us?
I do have one more question for you, Adam, or for Emily. I mean, I was just going to ask, like, you kind of briefly touched upon how, amending operating agreements, but can you talk a little bit about how an operating agreement can also evolve alongside, a business growing without losing sight of the original artistic objectives? Or how should that be if, the business does grow and something changes, how can that be reflected in a new operating agreement?
Yeah. So very often, if you look at operating agreements, you'll see this clause somewhere towards the start, essentially saying that this LLC can be used for any legal purpose. And that's usually what people are going to default to. They're not going to want to put something in their operating agreement saying, hey, we can't make these widgets because who knows where things change. So that's your starting point. But I think the thing to think about when things change is how fundamental are these changes? And that goes back to sort of the decision-making powers of if something is truly changing the direction of the company, do we want people to be able to unilaterally do that without the members' input? So really, you need to go back to what we were talking about really early on, which is set out how decision-making is made. Talk about the level of importance that certain types of decisions have and what sort of unanimous or majority or veto control needs to be written in there. So things may change, but if someone has a major issue with that, ideally the operating agreement is going to be able to be used to get in the way of that. Emily, do you want to add anything, or do you want to look at Karen's question?
No, I was just gonna read out loud the comment we had in, which is from Karen, and how do operating agreements address disability or death of one of the members, or is this addressed in other types of agreements? They generally do address the disability or death of a member. I've had this come up where suddenly in litigation, two people are running a business, one of them dies or is disabled, and one of them's sort of left holding the bag, and the person's surviving spouse or child or whatever is now 50% owner of the business. And so, yeah, this is something that does get very much addressed in operating agreements.
But you need to, if you are drafting one, and you have specific concerns, raise it with your lawyer, because I can tell you, we've drafted many, many dozens, if not hundreds of operating agreements. Lorraine and I definitely have language that we tend to like to include in those spaces. But again, it's really up to you. If you have specific things you want to bring up, or you even want to see what your lawyer suggests in those instances, ask. It needs to be addressed outright, though, and that usually is the place where it will be addressed.
Yeah, and it's probably good to, if this is a concern, to do this work in conjunction with a T&E, a trust and estates lawyer, or life insurance. Sometimes life insurance policies can be used to buy out a deceased member, so that may also be another person to bring into the discussion.
That's a great point. And I think with that, we're at the 1 hour mark. So I'll leave everyone with this. I want to thank Emily for joining us. Emily has a fantastic newsletter that talks about different matters that pop up in litigation, and a lot of it relates back to the creative industries. I learn a lot every time one of those goes out. So I highly recommend you look her up and add her to the list after this. We will be having more talks like this in the coming months. Our next one is going to be maybe the most exciting one we ever had, featuring two accountants, talking about tax season and what creators and artists should be thinking about. That is next month. We're going to be sending out details about that, probably starting later this week. Anyone has any questions? Yeah, February 12th. Anyone has any questions about anything raised today, whether it's myself, Emily, Lorena, please feel free to reach out to us directly. Emily, anything you want to leave?
No, I just wanted to say thank you, Adam, and thank you, Lorena, for doing the most of the work and organizing this and doing the presentation. I really appreciate it. And I hope people got something useful from this.
Take care, everyone. Enjoy the rest of your month, and hope to see you all next month.
Thank you, everyone. Bye.
Bye.